back to DMV, checking everything and checking, when folks send bills in and whether it's repairable or salvage and things of that nature. So we're sort of in a catch-22, but DMV and the auto dealers and all the others came together, got a consensus to move forward, and that's the bill, Mr. Chairman. Thank you.
So, operates by motion.
Motion to report with amendment.
Second.
Have a motion made and a proper second. Any further discussion? Hearing none, let's vote. Everyone's voted. So the bill passes recommends to report to the full committee 3-1.
Thank you. Thank you.
Thank you. Next up, we have, we're blessed today with a majority leader and assistant majority leader, so we'll have Delegate Quinn come forward.
Thank you, Delegate Runyon. I have House Bill 553, and I also have a fairly simple substitute that I would like to offer, and I can explain that substitute if you'd like. So the substitute actually makes three very sure. So the substitute makes three technical changes and then adds the Secretary of Labor in, and I'll explain why that's in there, Mr. Chairman. So House Bill 553 is a Section 1 bill, and I don't carry a lot of Section 1 bills because a lot of times I think that we carry Section 1 bills to just kind of make ourselves feel better about, something. However, there are times when we can pass Section 1 bills that actually do something, and this is one of those times. So we all know that we have a lot of supply chain and logistics issues in our country. And a lot of it is directly related to the lack of CDL and over-the-road drivers. That shortage is well known, and it's been building for a while. And so while we can't control what goes on in 49 other states, we can control what goes on in Virginia. And I feel like that we need to play our part because of our distribution infrastructure and even just the sheer number of interstates that we have here and the number of commercial drivers who are based in our state. So what this bill does is take off of something that my neighbor to the southwest, Tennessee, actually put together. Of course, this is a little better version than theirs, but nevertheless. So essentially what it does is takes the Secretary of Transportation, who will then work with this substitute, the Secretary of Labor and the Secretary of Public Safety, to identify laws, regulations, and policies that may be adversely affecting us. Because every time I talk to a different group, whether it's public, private, et cetera, everyone's got a slightly different take on why we're in this bottleneck that we're in. So then those three secretariats would then work with the Department of Veteran Services to figure out how we can do a better job of integrating veterans into this sector, as well as Department of Corrections. We're always talking about reentry and giving people second chances, and this is a heck of an opportunity. And then lastly would coordinate with our public institutions of higher education, probably most likely community colleges, as several have CDL training programs. So essentially what we want to do is pull everyone together in the same room, hash these issues out, figure out what we've got to do to try to get this issue fixed so that Virginia can step up and do our part.
Any questions of the other? Thank you. Is there anyone in the room wishing to speak in favor of the bill?
Good morning, Mr. Chairman, members of the committee, Subcommittee Dale Bennett with the Virginia Trucking Association. First of all, I want to thank Delegate O'Quinn for introducing House Bill 553 regarding the shortage of CDL drivers, which is actually the #1 issue for our industry in our annual survey over the last 5 years now, #1 for 5 years. The COVID pandemic and the recent stories about empty shelves and product delays have made us all more acutely aware of how essential and critical truckers are as the most important link in our supply chain. Our national organization estimates that the current national shortage is at an historic high of 80,000 drivers, We estimate that to be anywhere around 2,000 to 3,000 here in the Commonwealth of Virginia. And then projections show that we will need 1.1 million new drivers over the next 10 years. Addressing the shortage of CDL drivers in Virginia requires collaboration across several secretariats and agencies working together with the industry on positive solutions to grow our workforce and make our supply chain more resilient. We strongly support this bill to show the General Assembly's support of the need for this collaboration within state government to help us address this important workforce issue. I'll be happy to answer any questions.
Thank you. Any questions, any more members from the jury that wishing to speak in favor of the bill? Anyone wishing to speak in opposition to the bill? Move to report. Motion made and properly seconded. Motion made, properly seconded. Report with amendments. Good morning. That's a yes. So the bill recommends reporting to the full committee 5-0.
Thank you, Mr. Chairman.
All righty, so next we're going to take up Delegate Carr's bill, and the first bill will be House Bill 632. And good morning, Delegate. Good morning. Delegate, I believe you're muted. Yeah, there you go.
Thank you. Mr. Chairman, I understand there's a substitute.
That's correct.
Thank you.
Yes, there is I have a substitute for House Bill 632. I'll offer that. I've talked with the patron. She's in agreement with accepting this substitute.
Motion to report the substitute.
Second.
A motion made, properly seconded. Any further discussion? All those in favor of accepting the substitute, please vote. Aye.
Aye.
Opposed, like sign. Motion carries. Go ahead, Delegate Carr.
Thank you, Mr. Chairman. Mr. Chairman, members of the subcommittee, HB 632 targets noisy exhaust systems on our residential and business arteries. An overwhelming number of constituents and Richmond residents have contacted me about this issue, including one neighborhood with a petition of over 300 signatures. The exhaust systems are often modified specifically to maximize the noise of the vehicle, and their raucous noise is often paired with erratic and dangerous driving. Residents from both the north and south sides of the river and diverse neighborhoods complain about the noise they have to endure and how their quality of life is affected. This bill would allow police officers to pull someone over for operating an exhaust system that produces excessive noise. The target will be enforcement on those who intentionally modify their cars and rapidly accelerate to disrupt otherwise peaceful neighborhoods and shopping areas. Mr. Chairman, members of the committee, various members of the Richmond community are here to attest to the scope of this issue and emphasize the need for action.
Thank you, Delegate Carr. Are there any members of the committee that wish to ask questions? Okay, hearing none. I'm sorry, go ahead, Delegate.
To help explain the substitute, this will revert the exhaust provisions to a primary offense as it was before the 2020 special session. This will allow a state police to stop a car for loud noise. Right now, and we can ask Major Maxey if he could explain this, but right now they cannot stop a car because it is a secondary offense, and if they stop a car because of a defective system, they will get written up. because you don't know if the loud noise is coming from a broken pipe or if the muffler that's been changed. So the state police refuse to stop for loud noise now. I think this will solve the problem of Betsy Carr and others with excessive noise. So.
Thank you, Delegate. Any other comments?
I have a question. Does this include jake braking in terms of noise? Maybe I'm out of line with that question, but no? Okay, thank you.
Thank you. So is there anyone from the audience that wishes to speak in support of the bill?
Mr. Chairman, members of the committee, my name is Laura Bateman, and I'm here representing Richmond City Council, who is in full support of the bill, and thank Delegate Carr for bringing the bill forward.
Anyone else from the audience wish to speak in support of the bill? We have 3 members from the community that wish to speak virtually. Who manages that? We ready to let? Are they still there?
Yes, Mr. Chairman.
Okay, I didn't see it. I apologize. Yes, we would like Mr. Ryan or Mrs. Ryan.
Yeah.
You're muted.
You are muted again. We heard one little word from you. There
Can you
go.
hear me now?
Yes, sir.
Great. My name is Winfield Ryan. I live on 1826 West Gray Street, and I'm speaking on behalf of the Historic West Gray Street Association. And it's a matter of great concern, as we know, and you just stated for us, and all of the city of Richmond residents, is noise emanating from large numbers of vehicles, often driving in packs, such as motorcycles, souped-up cars, all-terrain vehicles. Some of these vehicles have been modified to create louder noise. And to enhance the noise they make, they often perform stunts such as wheelies on motorcycles, donuts, and speeding. Obviously, these types of activities present a loud, noisy, and dangerous situation. It's not a question of if a tragic accident is going to occur as a result of these activities. It's only a question of when a tragic accident is going to occur as a result of these activities. As evidenced by the Richmond police officer who last week was hit by a driver of a motorcycle who was driving in a pack with other motorcyclists while the police officer was directing traffic. The loud noise and obnoxious noise can occur at any time during the day or night. For example, it occurs during the middle of the day or during the early morning hours. The noise is particularly irksome when trying to put a baby to sleep or when your pets are being terrorized by the loud noise. When the weather is good, the problem becomes ever more prevalent and acute. You cannot sit outside your home if you live on West Gray Street and have a conversation with the person sitting next to you. This is a big deal. And it is a big deal for residents who reside in the city and workers who work in the city. And it's affecting the quality of our lives, as we've already discussed. And as evidenced by the petition signed by hundreds of Richmonders asking for a solution to this problem. So, in conclusion, the Historic West Gray Street Association supports House Bill 632, and we appreciate the efforts of our council sponsor for this bill. Thank you.
Thank you, Mr. Ryan. Ms. Weish, and I apologize if I butchered your name. You would be up next. Thank you.
Thank you, and good morning. You said that correctly. Thank you. I am president of the Randolph Neighborhood Association, and I'm here to support HB 632. Many cars that drive through residential neighborhoods with extremely loud exhaust systems are disruptive, as you've heard. And while Randolph is a very diverse neighborhood, it is home to a large number of senior residents who have overwhelmingly contacted me about the noise because they find it frightening and startling. You can expect to hear it randomly throughout the night at any given time. It's a nuisance throughout the city and negatively impacts the quality of life of many of our residents. We encourage you to support this bill and resolution of this matter. And I would also recommend that law enforcement be given the mechanisms to enforce these offenses. This is no less than a burden or a disruptance than some of the loud music coming from cars riding on city streets. I thank Delegate Betsy Carr for bringing this forward, and the Randolph Neighborhood Association would greatly appreciate your consideration for this bill. Thank you.
Thank you, Ms. Weiss. Next we have Reverend Robin Mines.
Good morning. I represent the Swansboro West Civic Association. We reside between Hull Street and Midlothian Turnpike off of Belt Boulevard near the Southside Plaza area. And we are awoken several times during the night, sounding as if we're in the middle of the raceway. I hadn't heard noises like that since I moved from Henrico near the racetrack. We have drag racing during the middle of the night. I don't know if there's a pit stop in the Circle Shopping Center, but it sounds like they sit over there and rev up their engines. And then they ride through our community from Hull Street to Midlothian Turnpike as well. I'm so glad that something's going to be done because it disrupts our sleep. It makes us feel like we're not in a neighborhood, like we're in an industrial park or something. And so I'm so grateful for Delegate Carr and the rest of you who will be supporting this bill. Thank you so much.
Thank you, Reverend. I believe we have no one else online to speak for or against the bill. Delegate Carr, you have the last word.
Thank you, Mr. Chairman. You've heard from our citizens, and as I've been hearing from them every day, and I would be so pleased if the committee would see fit to move on this measure. It would really help our neighbors in the city of Richmond and what's going on. Thank you so much.
Thank you.
Move to report the substitute.
We have a motion to report and a substitute. Any further discussions? Hearing none, let's go to the board. Thank you. I think everybody's voted. The bill reports forward to full committee at 5-0.
Thank you, Mr. Chairman, members of the subcommittee.
Thank you, Delegate. I think we have another one. While we're on the car roll, we'll head on down to House Bill 641.
Thank you. Thank you, Mr. Chairman. Mr. Chairman, members of the subcommittee, HB 641 is a narrow surgical fix to a very specific problem. Under the American with Disabilities Act, paratransit passengers who are unbanked must be allowed to pay cash for an ADA-eligible ride. Transit systems, for example, Richmond's GRTC, contract service providers to meet the need of ADA-eligible riders. Sometimes these contracted service providers are transportation network companies. The current licensing statute precludes TNCs from accepting cash fares. This creates the issue my bill seeks to fix. A TNC being contracted by a transit system like GRTC can't give rides to an eligible paratransit passenger if they are unbanked, because this would require them to accept cash fares. This bill is as simple as this. In order for wheelchair-bound passengers who do not have credit or debit cards to access transit systems for transportation, we need to make this change. If we do not make this change, cash-paying transit riders will not be able to access TNCs. Mr. Chairman, members of the subcommittee, Hunter Jamerson, representing USERV, is here to speak to the bill and will help answer any questions.
Thank you, Delegate. Any questions before we move to the speakers? All right. Mr. Jamerson.
Good morning, Mr. Chairman, members of the subcommittee. Hunter Jamerson, representing USERV. USERV is headquartered in Delegate Carr's district. We're very grateful for her bringing the bill forward. USERV is the third licensed TNC in Virginia. You have Uber and Lyft and USERV. USERV provides jobs to 1,000 drivers in Virginia, offers rides to thousands of patients in each city that it services. As Delegate Carr has explained, we have a business challenge in that federal law requires us under the ADA to accept cash from certain wheelchair-bound riders who are eligible for an ADA-compliant ride in order to pay their copayment. But we have a state law challenge in that our licensing statute says can't take cash ever. As Delegate Carr explained, her bill provides that business solution to allow us in that limited circumstance, following a defined protocol, to accept cash. This is not a novel approach. This issue has come up in other states as well, where the licensing statutes prohibit cash. Most recently, the state of Ohio unanimously adopted the same protocols for cash acceptance. So we think this solves a business problem, offers access to wheelchair-bound riders, and appreciate if you would advance the bill.
Thank you. Any other members of the audience to wish to speak for the bill?
Good morning, Mr. Chairman and committee. Thank you for being here this morning. And Delegate Carr, thank you for bringing this bill forward. My name is Michael French. I represent USERV, and we fully support this bill. Thank you.
Thank you, Mr. French. Anyone else wishing to speak for the bill? Anyone wishing to speak in opposition to the bill? Seeing none, and we have none online. Delegate Carr, you have the last word.
Thank you, Mr. Chairman. I think the committee has heard the arguments in favor of this bill, and would really appreciate looking at it in favor.
Thank you, Delegate Carr. Committee operates on motion.
Second.
We have a motion properly seconded. Any further discussion? Hearing none, let's go to the board. Again, we're on a roll, 5-0. Bill is recommended to report to the full committee. We are.
Thank you.
Yes.
Thank you, Mr. Chairman and members of the subcommittee.
Thank you,
Appreciate
Delegate Carr. All righty. So next up, we're going to take Delegate Watt's bill, House Bill 367. And we appreciate your patience, ma'am.
There is a substitute and a handout. Thank you, Mr. Chairman. The bill that the committee has acted upon just takes us back to where we were before March 1st, which throughout the region that I am most familiar with still had the problem to absolutely the same degree, and 1049 was not an effective tool to deal with what I have fondly now called the macho muffler problem. The issue, as I have looked at this, and we were kind of exchanging before the committee started, when I do a notebook on a bill, it's serious, and I've got an ever-growing notebook on this one. As I started approximately 6-8 months ago on behalf of a number of members of the Northern Virginia area who were experiencing this problem most seriously. And we were being blamed that it was because of changing 1049 to a pretext stop that all this was happening. And yet, if you go on the website, you will find a number of news accounts of this happening 4, 5, 6 years ago, not only within Northern Virginia, but within the region. The handout that I have provided for you does include these two particular screenshots over just one of several videos that I have been sent over the years, over this last 6-8 months. Again, this one is dated March 23rd as it exploded still again in this particular neighborhood. These are not the sounds of mufflers in disrepair, which is what 1049 is all about. This is much more than that. And as I have met with local law enforcement, as I have met with our county attorneys on repeated meetings, state police, a number of attorneys trying to separate this out, I realize that there is no one solution. None of it's going to do it all, but all of us are ways of getting at it. Therefore, the approach in HB 367 has 5 different aspects. First of all, our definition of these enhanced muffler sounds in 1047 goes all the way back to what I know as American Graffiti days. It's very specific. It has just a couple of pieces of equipment named, and because only those pieces of equipment are named, then you can't do another piece of equipment, or now in modern times, an electronic way of producing this same kind of noise. So therefore, and I have annotated it to the substitute that I hope the committee will adopt. Therefore, what it does is expand this so it's generic and is encompassing of any added equipment that produces this kind of enhanced noise. It also then establishes a new code section, 1047.1, where it's not the matter of just the equipment, because the problem with the equipment on the roadside, even if you have 2 officers in the car, you are not going to, at the risk of your own safety, get down on your hands and knees and try to detect this equipment. And I have been assured by law enforcement that if you make a 1049 stop because you think there's 1047 equipment, you will be wrong at least half of the time, or you will not be able to detect it in this kind of a roadside stop. So what 1047.1 does is now creates not the piece of equipment, because again, there are national websites, very robust websites, that rate Virginia as a piece of cake to get around, because it's just equipment. So what 1047 does says any driving of a vehicle in a way, and I have used these words from other states that take this approach, that produces a unnecessary, unusual, excessive sound will be in violation of 1047.1. Now, even though in some areas of the code that might be acceptable to just have those words, I've tried also in the substitute with advice in talking through this with counsel to also describe a sound level that is far above a muffler in disrepair, just a rattled muffler in 1049. What 1047.1 is describing by reference, and the reference which uses estimated to be, has been upheld in an unwritten appeals court decision in Virginia as far as detecting speed, that it is acceptable evidence in court to have an estimate of speed, and it doesn't always have to be measured by. And the reason why this is very important when it comes to sound is that sound isn't like speed. You can identify on that speed camera which car is driving at an excessive speed. But when it comes to a sound meter, the sound that the meter is picking up is going to be affected very much by the other vehicles going by what it's bouncing off from, whether it's hard buildings or trees, what the weather is. There is no accurate measure, but it's saying an estimate of 85 decibels at 50 feet, again, used from other states that take this approach. Now, what does that translate to at the muffler, at 20 inches? As I have looked at all of the comparables on this, essentially we're talking about a jet taking off and you're 1,000 feet below. 1,000 feet is 3 football playing fields. Very close. It is a chainsaw. It is that level of excessive, unusual noise. And while this will be something that will be tested in case law as these cases go through the courts, it gives a relative measure for what is very tricky in measuring sound. And let me stay one more moment on this issue. It will be tested in court. These aficionados, these clubs, these very expensive equipment in a number of instances, this is their serious hobby. And I can assure you there is the wealth and the focus to test this in court, to take apart any such arrest, making it based on just a general statement of noise. So in addition to that, the bill also, for Virginia residents, makes the presence of such equipment an element to fail an annual inspection. And the reason for putting in that aspect is that only then can you have a physical inspection of the vehicle. Any other circumstance you cannot. This also will allow by reg, as is typical in the other states, to determine at the muffler what a comparable sound measure might be of this piece of equipment. Although, again, the enforcement is of 1047, not of 1047.1. In addition, it is extremely important.
I don't think we've adopted the substitute yet. Is that correct? So can we move the substitute so everyone can see?
Second.
Okay. Paul?
Thank you.
We have a motion made, properly seconded. All those, any further discussion? All those in favor signify by saying aye. Aye. Opposed, like sign.
Thank you.
So substitute's adopted.
I do appreciate that. And the next two aspects of the bill, 4 and 5, that are added to it, right now and for a long time in the code, law enforcement can go onto parking lots, warehouse lots, school and churches, etc., and enforce any traffic infraction that endangers life or property. This uses that same language and applies it to this violation. So it will allow, in the kind of instance that I showed where we are hearing it and that Betsy Carr's constituents also spoke in terms, this will allow enforcement in these circumstances. And then finally, because, again, the specificity of local noise ordinances is tied specifically to off-road vehicles operating off-road. If it wasn't that specific, we wouldn't have any problem. Therefore, in several places as necessary, it is clarifying that a local ordinance can be enforced against a vehicle operating anywhere on road, driveway, etc., which is also a source of where this occurs. So with that, while none of it's a silver bullet, all of it is essential for dealing with the use of this type of equipment and giving law enforcement and local governments an opportunity to deal more effectively with this problem than whatever existed with or without the pretext stop of 1049.
Thank you, Delegate. Any questions of the delegate?
Just a few quick questions. It looks like to me that you're putting this noise ordinance into the safety inspection program.
I understand that, Delegate Bloxham, and I understand. And I know that state police will have to make that same point, but this is the only way to physically enforce our law.
Okay, so I've got a comment about that also, but would that mean that every inspection station would have to buy an 85 decimal meter to qualify for this?
The state police estimate, and this was in the original bill as well as the substitute, was $53,000 required as far as fiscal impact
for the state police, but that doesn't count the meters that I would have to buy one also in my state inspection. My 2 state inspection stations. Is that not correct?
My understanding of the fiscal impact statement does not match what you say, but if you are more familiar with this than I am, and so I accept.
And hence the other day when I came by and I said I have a major problem with the bill. I see what you're doing in the substitute. I really think that what we've done with delegate cars will help with your issue.
It'll only take us back.
Exactly, where it takes us back to where the state police could stop and inspect a vehicle. And if I'm not mistaken, and we can ask Major Maxey, the amplifying noise, all that is illegal. But I'm not in law enforcement as an inspection station. All I care about is the safety of the vehicle. So the safety of the vehicle is there a break in the exhaust system so fumes can get into the cabinet? So that's what I check. I don't check noise. I don't check anything else to do with the exhaust system. I mean, this is going to be ramifications all the way through every inspection station. So we can keep going, but the clock is running out, and there's no way I can support this.
Delegate, if I may respond to Delegate Bloxham more accurately, this is evolving. There is nothing in the language that says you have to measure decibel. The language says enforcement of 1047. It does not say enforcement of 1047.1. Therefore, you are physically looking for that piece of equipment. It is possible that as you move forward on this, there's nothing precluding it, but it does not require the measure at 20 inches from the exhaust, which is something you cannot require a driver to do at the road.
Thank you, Delegate. Any further questions? Is there anyone wishing to speak in support of the bill from the audience? We are in the interest of time, and so we have several more bills to address. So that everyone gets a fair hearing, we're going to limit to 1 minute.
Mr. Chairman, Noel Dominguez with Fairfax County, and I'll keep it fairly short. We want to thank the delegate for working with us and speaking with us as she was crafting this legislation. We are supportive of the provision, specifically in relation to the items, the devices that do amplify or create the noise further than what is necessary, what is required. So thank you very much.
Thank you. Anyone else wishing to speak in support of the bill? Anyone wishing to speak in opposition to the bill? Yes, sir. We have someone. Delegate.
Mr. Chairman, Matt Danielson, Virginia Coalition of Motorcyclists. We oppose this bill. We certainly look at our exhaust not being able to be seen as easily as a safety issue, being able to be heard, but we also understand the concerns, which is why we support Delegate Carr's bill as substituted. 85 decibels is about the level of a blender. It's the first thing that comes up if you Google it. And there's a reason why a minority of states use decibel levels when it comes to exhaust. It can lead to inconsistent enforcement. Besides the cost of getting them, in most states that have it, not every officer is equipped with them, meaning if someone's stopped because we think maybe they're over 85 decibels, they have to sit there and wait until another officer comes along that has a decibel level, a decimeter. We just believe it's a bad way to do this, and we think that Delegate Carr's bill adequately addresses the situation.
Thank you. Anyone else wishing to speak in opposition?
Mr. Chair, members of the subcommittee, we appreciate the delegate bringing forward this measure and know this is a difficult issue, and the solution is a little bit more complex. I just wanted to highlight our new franchise car and truck dealers. They do sell vehicles that are above 85. We have a significant amount of vehicles out there that would put us in a difficult position selling cars that are going to be above the 85 decibel level. Thank you.
Thank you. Anyone else wishing to speak in opposition? Major Maxey, Virginia State Police.
Mr. Chairman, Ron Maxey, Virginia State Police. Just to address the question as far as the fiscal impact, the $53,000 was to equip each of our 52 inspection troopers. That would be required to go around to the stations. The devices are approximately $1,000 on the cheap end, so that would be left up to the private business to absorb that cost on their end if this was part of the inspection program. Concern that we have from the inspection program is that this is a noise issue, not a safety issue. The inspection program is built on the premise that we are there solely to check that that vehicle meets the minimum safety standards. This would get us out of that lane into enforcing regulations, state law, and it would lead us down a path that we feel would undermine the integrity of the program itself. One of the issues with having an inspector check under 1047 is that it says any mechanical or electronic device that creates or amplifies noise emitted by the motor vehicle, moped, etc., that is louder than the noise emitted by the motor vehicle, moped, or motorized skateboard or foot scooter as originally manufactured. That's going to be more time to the customer that comes to the inspection station as well as to the inspector to figure out what that vehicle is manufactured at. Thank you.
So committee operates by motion.
I move the bill on the table.
Final word.
Pardon?
Quickly.
Very quick,
Yes.
we're out of time.
I do understand that. I also have a letter from the Prince William County Board endorsing this.
Thank you.
And finally, I would say that, please, 85 decibels is at 85 feet. I mean, at 50 feet. It is not at the pipe. So
Thank you,
please,
Delegate.
it is not a blender.
Yeah, and we're happy to take your Prince William thing. Committee operates by motion.
Move to lay the bill on the table. Second.
Motion properly seconded. I believe this is a non-debatable item, so all those, please signify your vote on the board. I believe everyone's voted 4-1. Bill's laid on table. Delegate Watts, thank you very much.
Thank you, Mr. Chairman, members of the committee.
So Delegate Lopez, I believe you're up next. And if we can move with dispatch, but fair. How's that?
Thank you, Mr. Chairman, members of the committee. I'm here to talk about something that I think unites the residents of Northern Virginia, and specifically my community in Arlington, more than any other. The intense, actually crosses party lines, the intense level of frustration about overly aggressive and predatory towing. The situation in Arlington has actually gotten so bad that one tow company was recently sued by the Attorney General for its aggressive practices. The AG's office argued that the company often towed vehicles unsafely and at times even towed without the proper legal authority to do so. The complaint alleged that the company employed tow truck drivers who did not have the proper state registration, even that the company targeted delivery vehicles and police cruisers in order to boost their numbers and increase profits. During the case, several Arlington police officers took the stand to testify that the numerous tickets that had been written out to this company's drivers over the last few years due to improper towing practices. Though the court ruled that the company violated the law, it was only charged a civil penalty of $750, just barely more than the fees they charge for towing a few vehicles. Why? Why? Let's see him go by. Why? The code is a mess as it relates to towing in this regard. This case highlighted a glaring series of problems with Virginia's current laws governing towing companies, which my bill was crafted to address. As it currently stands, only the Office of the Attorney General is authorized to enforce the current list of prohibited practices for towing companies in the code, as well as to seek restitution, injunctive relief, and attorney's fees from companies found to have engaged in these practices.
Okay, please. Excuse me. Go ahead.
Sorry. Yeah, so just to repeat, as it currently stands, under this code section, if you have a problematic towing company, the only group that can sue that towing company is the Attorney General's office. On top of that, the Attorney General is constrained by another section of the code to seek only civil penalties of up to $150 per violation if they occur in Northern Virginia Planning District 8. Let me repeat. They're only allowed to get civil violations of $150.
Delegate, I think we've got
it. All
Don't
right.
need to repeat.
HB 1218 would ensure that towing violations are subject to the Virginia Consumer Protection Act and would clarify that the Office of the Attorney General, Civil Investigative Demand Authority, is applicable in these matters. The bill also makes changes to ensure that courts can impose meaningful civil penalties, not just limited to Northern Virginia, and to allow for individual enforcement of prohibited practices rather than solely through the AG's office. Virginia deserves better than the harsh and haphazard treatment they receive from predatory towing companies like the one in Arlington. This is an issue most Virginians have strong feelings about, no matter what region they're from. I hope we act now. Thank you, Mr. Chairman.
Thank you, Delegate. I appreciate that. Is there anyone here wishing to speak in favor of the bill? Quickly. Is there anyone here wishing to speak against the bill? Quickly.
Very quickly, Mr. Chairman, members of the committee, Greg Habib from Gentry Lock here on behalf of Coalition of Tow Truck Drivers. The law already prohibits this behavior. The law already creates a civil cause of action. The law already gives to the AG jurisdiction. The only thing this bill would do was let lawyers like me make more money by collecting our attorney's fees and claims. We think you should defeat the bill. Thank you.
Well, Mr. Habib, I appreciate your candor on your income statement there. So thank you. Anyone else wishing to speak against the bill? And I do not believe we have anyone online. So last word,
Mr. Chairman,
2 words.
The gentleman, and I use that term loosely, said that only the AG's office is able to prosecute this. That's inherently unjust. And as I said before, you're only allowed to get a civil fine or penalty of up to $150. This is a mess for this part of the code. This bill tries to fix that. I hope it's the will of the committee to fix that as well.
Thank you, Delegate. I appreciate your comments. Committee operates by motion.
Move the table.
I have a motion.
Second.
Second, properly second. It's non-debatable. So let's record our vote on the board. Okay, we got it. So the bill is laid on the table 4-0. Thank you, Delegate. We appreciate it. And we have our last bill. Delegate Scott, you have a motion?
Yeah, Delegate Scott, the patron has asked to carry this bill over till next year, and I so move.
Second.
So we have a bill, a motion on the table, properly second. Any further discussions? So it's voice vote. All those in favor signify by saying aye. Aye. Opposed, like sign. Bill is carried over to next year. Thank you.
Thank you, Mr. Chairman. Nice work.
So we're adjourned.